our next speaker will be Tara Davenport. She's assistant professor with the Faculty of Law with the National University of Singapore. And it's interesting, so Kent mentioned that most of the problems come from, let's say, cohabitation issues, like commercial fishing activities, sanctioning activities interfering with the cables, that's 70% of the problems. But, sometimes the damage is intentional as well. And then Tara will focus on that part as well, what does international law says about that and how we protect about, against those intentional activities, but also generally what international law says and how it helps, cable providers to protect what is a critical infrastructure. After you, Tara, please.
Thank you very much. Can you hear me?
Yes, we can very well. Thank you.
Yes. Okay. Great. Thank you. Good morning, everyone, or good evening. I'm dialing in from Singapore at the moment, where it's just about 6 o'clock. Thank you very much for the invitation from the organizers, and I am delighted to be presenting at this very important event. And thank you again to the Portuguese government and to Jose Barros. As you were saying, Tomas, my presentation is on whether international law, that is the law governing the relationships between states, is sufficient to address the intentional interference with submarine cables and related infrastructure. But perhaps after Ken's presentation, my question should be whether international law is necessary in this particular context. Given the time limits, I can only give a snapshot of the relevant issues, but happy to discuss further during the Q&A. This is, Kent went through it just now, but to reiterate, the overwhelming majority of cable faults are caused by accidental or negligent human intervention from fishing and shipping and other man-made activities. This is quite an old pie chart, but I think the sort of general proportion of faults is still accurate today. I've taken a very broad view of intentional interference for present purposes, right? They can consist of physical attack against submarine cables on the seabed or against cable landing stations, or they can consist of a virtual attack, right? On network management systems operating the cables. The overarching objective of intentional interference would be to cause intentional disruption to the myriad of services that cables provide. Right, so are there any incidents of intentional interference? Again, very few. These are based on sort of newspaper reports, not been able to verify them. The first three items I've put down here happened during conflict, World War I and World War II. And again, the others are sort of theft, intentional damage, some cutting of cables. However, we don't know the motivations, right? What motivated these particular instances of intentional interference. So intentional physical interference with submarine cables at sea, it is very challenging when you think of the logistics and the things that are required. You have to identify the cables of interest. You have to use vessels and other equipment to damage the cables. And this would also require substantial financial resources. Virtual attacks on submarine cables are more likely to occur than physical breaches at sea. And this is according to a report by a think tank in the US, the CSIS report 2021. And again, I would like to reiterate that the consequences of intentional cable interference for countries with a diverse set of connections are likely to be less significant as traffic can be rerouted to other cables. Likewise, consequences may be more severe for countries with fewer subsea connections. Again, this is from a 2017 report by the US, I think it's a US think tank. Again, it shows the threat matrix, right? So the malicious instances of malicious interference with submarine cables, we classify it or describe it as a low probability but high consequence event, because obviously we are so reliant on submarine cables that intentional interference can have severe and significant consequences. So again, the international law governing it should not be cyber attacks, it should be attacks against cables in peacetime. It consists of a multitude and a patchwork of different regimes, of different international law regimes, such as the law of the sea, international telecommunications law, terrorism law, and the developing law on cyber attacks. So of course, the law of the sea, which is my expertise and interest, the 1884 Convention on the Protection of Submarine Telegraph Cables was one of the earliest law of the sea international conventions, prompted by the need to protect submarine cables in the North Sea. It's a very old convention, consists of 10 articles, and some of these articles were incorporated in the 1956 ILC draft articles on the law of the sea, and then in the 1958 Geneva Conventions, and then finally incorporated in the 1982 UN Convention on the Law of the Sea, which presently has 168 parties and is generally accepted as a constitution for the oceans. The preamble of the Law of the Sea Convention clearly states that it sets out a legal order for the seas and oceans which will facilitate international communications. So the Law of the Sea Convention addresses two aspects relating to submarine cables. Firstly, the laying, repair, and maintenance of submarine cables, and then the protection of submarine cables. I'm sure many of you are familiar with this, but I like the colorful diagram. We have the internal waters, the 12 nautical mile territorial sea, the contiguous zone, then you have the exclusive economic zone, right, which gives the coastal states sovereign rights over the resources, both living and non-living. Then you have the continental shelf regime and the extended continental shelf regime beyond 200 nautical miles, which again, the coastal state has sovereign rights over the resources. And then you have the high seas, and of course the area, which is the deep seabed, which is designated the common heritage of mankind. And high seas and the area are areas beyond national jurisdiction of states. Law of the sea, in areas under sovereignty, right, which is the territorial seas, international straits, archipelagic waters, there's actually very little about the protection of submarine cables. In the territorial sea, there is one provision that says the coastal state has the right to regulate innocent passage of foreign vessels for the protection of submarine cables. In international straits and archipelagic waters, there's no explicit provision on the protection of submarine cables. In areas within national jurisdiction, but beyond sovereignty, the continental shelf and the exclusive economic zone, where the coastal states do not have sovereignty, but they have sovereign rights over the resources, there is an obligation, I think, which Ken referred to earlier, on states to adopt laws and regulations criminalizing the damage to submarine cables in the high seas. So the high seas obligations applies in the continental shelf and the exclusive economic zone. And as I put here, again, there is an obligation on states to adopt laws to ensure that damage that occurs either on the high seas or in the exclusive economic zone or continental shelf are criminalized. However, this is a notoriously inadequate provision, particularly for intentional interference with submarine cable systems. It says states must adopt laws and regulations to provide that a breaking or injury by a ship flying its flag, so flag state jurisdiction, or by a person subject to its jurisdiction of a submarine cable beneath the high seas, done willfully or through culpable negligence, is a punishable offense. So of course, the idea of something done willfully encompasses intentional interference with submarine cables. However, I think as Kent has also explained, it has been inadequately implemented by the majority of states. Many states don't have this provision in their national legislation. Actually, in any event, this provision also provides only very limited grounds to exercise jurisdiction. It only gives the flag state and the state of the nationality of the perpetrator the right to exercise jurisdiction over acts that are committed outside the territorial sovereignty of the coastal state, of that particular state. Again, only applies to the high seas and exclusive economic zone. I would argue that it only also applies to physical attacks rather than virtual attacks. And it does not mention enforcement or the right to interdict other vessels suspected of damaging cables at sea. And this is actually in contrast to the 1884 Convention, which has a provision allowing some form of limited interdiction against vessels that are suspected of damaging a submarine cable, either negligently or willfully. International Telecommunications Law. Sorry, I'm just checking my time. Of course, ITU is a UN agency that establishes international standards for information and communication technology. Article 38 of the ITU Constitution, it says members shall take such steps as may be necessary to ensure the establishment under the best technical conditions of the channels and installations necessary to carry on the rapid and uninterrupted exchange of international telecommunications. Members shall safeguard these channels and installations within their jurisdiction. Again, these are very vague obligations on member states to safeguard installations used for telecommunications. It is a due diligence obligation. It is one of conduct and not result. States only have to show that they took reasonable measures, right? And financial and technical capabilities of states would also be relevant, right? And again, a question arises, is it only applicable in the territorial sea? It applies to channels and installations within member states' jurisdiction. Terrorism conventions, there are 19 terrorism conventions adopted by sector, right? And certain conventions may arguably apply to intentional interference with submarine cables. The 1997 Convention on Terrorist Bombings covers intentional damage against an infrastructure facility, including facilities used for communications. There is a draft comprehensive convention on international terrorism, which criminalizes serious damage to public or private property, including infrastructure facilities, which is likely to result in major economic loss. And then the 2005 protocol to the Convention for the Suppression of Unlawful Acts Against Safety of Maritime Navigation prohibits the using of a ship in a manner that causes serious damage, which includes damage to an infrastructure facility. There is still uncertainty. Do the terrorism conventions apply, and which one? Do they apply to landing sites only and not to cables on the seabed? And do they cover virtual attacks? Again, an area mired in uncertainty. The international law on cyber attacks, and I know we have an expert here, so I won't talk too much about this. But again, there is no accepted definition of what constitutes a cyber attack. I put here some old definitions: a deliberate action to alter, disrupt, deceive, degrade, or destroy computer systems or networks. Any action taken to undermine the functions of a computer network for a political or national security purpose. Again, it's still in its nascent stage. It is piecemeal and fragmented and does not, or arguably does not comprehensively address the security challenges posed by cyber attacks. The speed and enormity of cyber attacks makes proving state responsibility and distinguishing among the actions of terrorists, criminals, and nation states very difficult. In 2015, you can see the UN Governmental Group of Experts on ICT established some norms applicable in peacetime, including a recommendation that states should not conduct ICT activity contrary to its obligations under international law that intentionally damages critical infrastructure or otherwise impairs the use and operation of critical infrastructure to provide services to the public. In 2017, the Talon Manual, which is sort of a group of experts, they produced the manual which reflected the agreement that infliction of damage to cables by a state is prohibited as a matter of customary international law, since doing so would run contrary to the purpose of the law governing submarine cables. So again, my conclusion, international law applying to intentional interference with submarine cables is fragmented, inconsistent, and uncertain. It is certainly insufficient to address the low probability but high consequence event of intentional interference with submarine cable systems. But my last question, and perhaps I haven't answered it in my slides, is international law the solution? I'm very happy to discuss that further. Thank you very much.
So thank you very much, Sarah.
I think I have met my time.
And so the question is international law a solution? I know it's a weird question for the lawyer to ask themselves, but like, do you think is there any developments in the international law that could still happen and then help it, or like, do we need other measures, and to supplement that? So.
Yes, I mean, obviously I put the question there because I have the answer to it.
Please.
From I'm an international lawyer, an academic, obviously, we tend to have a very optimistic view of international law, and that is a panacea to the world's problems. But of course, there's several challenges in developing a robust international law, a legal regime governing intentional interference. I guess the first question, which is I've always wondered, is whether physical and virtual attacks should be addressed together. And my instinct tells me that the answer is probably no. It involves different governmental agencies and different methodologies and different prevention and enforcement methods. But to me, what's interesting is from I guess, a language and a legal perspective, the developing law on cyber attacks is broad enough to encompass physical interference. So that's just one thing to bear in mind. The second issue, and I think Kent also raised this, is there a sufficient risk of interference with submarine cable systems to warrant the negotiation of an international treaty? For example, some have called for an international treaty modeled on the terrorism conventions, which would sort of make the intentional interference with submarine cables an international crime, provide for universal jurisdiction. It would establish mutual cooperation on prevention and enforcement. However, again, this would require sufficient political will on the parts of states to even begin this process, and I have not seen an appetite for this on the part of states yet. And of course, this is coupled with the perennial problem that there is no intergovernmental organization which has the exclusive mandate to champion the cause of cables. Again, the third challenge, and I will very quickly round up here, is that states may not be able or not be willing to regulate in any sort of binding form intentional interference with submarine cables committed by state actors. And you can see this sort of exemplified in the realm of cyberspace, where there's a development more of soft law and non-binding instruments. And again, the last challenge, which is a structural problem with international law, it is notoriously slow to address problems and is usually very reactive. And again, I would say a more feasible short-term solution, as I completely agree with Kent, is to focus on sort of the industry and cooperation between industry and national governments in order to protect this critical communications infrastructure.
Thank you.
And I will stop there.
Thank you very, very much, Tara. And really, it's great and great insights, and also, both challenges, but also hope, because there are some solutions. You just need some political will, and we see that political will is being built up, especially because submarine cables are so important. So hopefully we will see a bit more activity there and a bit more push for some of your recommendations actually to come into life, and not just rely on soft measures. But thank you again for joining us so early this morning for you, and thank you for insight.